Because I'm really at the beginning of this project in many ways, although I think I have a handle on the legal questions, or at least the doctrine that I'm interested in. So what we see in trademark registration and its role in the broader trademark system is kind of a forehand backhand. Registration is substantive, and then it's just procedural. So registration is substantive, and the people who were writing at the time the Lanham Act was enacted were very clear on this, that it was substantive, in particular that it was substantive in that it provided for incontestability, for descriptive terms that survived long enough, and that they saw the nationwide scope of a registration as creating substantive rights where there were none before. On the other hand, it's procedural. So that is, we use the same infringement standard for registered or unregistered marks. So it doesn't give you any extra rights in that sense to have a registration. We also have doctrines under which descriptive marks' strength can be limited to essentially zero. So even incontestability does not have the exclusive effect that you might have thought it was. And actually the court in KP Permanent addresses a very well-developed historical argument explaining that the drafters of the Lanham Act really thought that exclusive meant exclusive, as you can understand. It's a position that is not clearly unreasonable to take. And therefore, the defense of descriptive fair use had meaning even if it required the defendant to prove that a high degree of confusion was unlikely. But the court, because it has the modern view of the Lanham Act, couldn't understand that at all. Because it's always a plaintiff's burden to prove confusion, then the descriptive fair use defense would have no meaning if you interpreted it that way, which is true, except the point was that the people, at the time the Lanham Act was enacted, people thought that exclusive meant exclusive. And so once you abandon that, a whole bunch of other things have to change. Likewise, in terms of nationwide rights, Dawn Donut takes back the substantive rights that registration was thought to confer. And finally, we now have B&B versus Hargis, where I think the best reading of this is to say that trademark registration is procedural, in that it doesn't give you any extra rights, which is why the court says it is just a different venue for deciding the same question, therefore preclusion can apply. And then the backhand is the majority comments and then Ginsburg rights and concurrence, but that's rarely going to happen because of these other things that go on in the registration inquiry. A couple of other areas where this occurs, so registration is substantive, it says the pro football court. That is, registration has a certain meaning, it is not coextensive with protectability, and therefore the cancellation of the Redskins mark won't preclude protection for them. But Judge Moore in In Re Tam, at basically the same time, says, no, registration is procedural, which means if you can't get a registration, you can't get protection, which means that there are a lot more First Amendment problems with 2A and, although she doesn't say it, with the common law that excludes protection for certain kinds of marks for reasons other than protecting consumers. So, one more version of this. So substantively, if we treated registration as having some meaning, then the registration of a standard character mark would give you broader rights than registering a word in a particular font or presentation. And so it does in PTO proceedings, where the PTO carefully says that having the standard character mark does give you broader rights to prevent other people from registering things. But backhand, and I don't think it's accidental that it's the courts here who basically do the backhand. And there may be something in here about the idea of crystals and mud in property law, where, as Carol Rose says, courts are the ones who see the aftermath and therefore have this impulse to do equity and kind of clean up the messes allowed by crystal and means. Then, if you look at the courts, registration turns out to be procedural. That is, the courts say that having a registration in a standard character mark gives you no more rights. And the people occasionally try this argument. It's interesting. You would think that trademark owners would try it more often in the courts to say, I have a standard character registration, my rights should be broader. But consistent with the idea that we've sort of forgotten the origins of the Lanham Act's concepts here. Most of them just don't even bother to try. Palm Wonderful recently did in the Ninth Circuit, and it was, you know, it's the Ninth Circuit, anything can happen, why not give it a try? And the Ninth Circuit did a very interesting thing. It said, yeah, it's true, you have a registration in the standard character mark, and that is broader than a registration of a particular design, citation to a bunch of TTAB cases. Now let's apply likely confusion doctrine and comparing it to the mark that you actually, comparing the defendant's mark to the mark you actually use, right? And so it had no impact on the actual allocation of rights as between this particular defendant and Palm Wonderful. Similarly, and I think this is a place where trademark owners have successfully been able to use the registration system without courts understanding that's what they're doing. There are cases where people have registrations for, say, a design mark, which they then attempt to turn into a registration for the image of the thing, no matter how presented. And I think it's partly because courts aren't so good with handling images, something that I've talked about before, that they don't notice this. When they do notice it, when the register tries to do it with the word. But the best example of this to me is this recent Mardi Gras bead dog case, where the plaintiff has a registration for a particular picture of a Mardi Gras bead dog, which is a little toy dog made out of Mardi Gras beads, and then sues somebody who makes a Mardi Gras bead dog jewelry, that is, you know, earrings and so on, in the shape of Mardi Gras bead dogs. And if courts understood what registration was, it would be obvious that there is absolutely no claim here, because the defendant is not using anything like that particular image, but because the court understood the registration to be the Mardi Gras bead dog, however presented, then the court sort of takes this claim seriously. This ends up backfiring on the plaintiff because you can't get a registration for the Mardi Gras bead dog for a variety of reasons. But it is interesting to me that the court didn't even notice the sort of foundational problem, at least from a registration viewpoint, which is, you know, that's not what they owned. So there's also similar things going on with dilution, but I don't want to go too deep into that. The project tries to set out this forehand backhand, and then ask, well, should we choose? Okay. There's a reason, perhaps, that we have both the substantive and the procedural elements of registration. So there's an argument to be made that it is either at least inevitable or perhaps even desirable that we have the courts sort of doing this procedural backhand, no, registration doesn't mean all that. My bias is that actually we probably should choose, and in part it's because I value predictability more highly, which is to say, if there's no coherent theory telling you when registration has substantive meaning, you can't tell when you're going to get the backhand. This is why it made sense for Palm Wonderful to at least try to say, hey, we have this registration, we have this doctrine that says the standard character mark means something. And you know, there's one district court that has accepted this theory. Someday somebody's going to do that. And I don't think it's a good idea to have no coherent theory of when we do that. Then, of course, if we choose, the question is, what should we choose? Should registration be, as it was before the Lanham Act, just procedural? Or should it be something that confers substantive rights on a registrant, allowing them, for example, perhaps to suppress uses in areas of the country they are not yet operating in? And I think there are potential reasons we might want to go in that direction, at least if it were accompanied by an understanding that the substantive rights themselves are so significant that they should only be granted after careful scrutiny. And I think that actually feeds in with Jeannie and Barton's point that if the register is getting too crowded, we have a serious problem on our hands. So that's where I am, and I would really love to hear from you because I am very tentative in my conclusions so far. And I know Jeremy completely disagrees with me on this.
I don't necessarily disagree with you on this, actually. I have decided to take a breather on this, actually, because I'm gonna see what the federal search does. But
so a lot of the clients I work with in New Orleans are small businesses, and the registration is sort of a complete federal registration, a completely optional process, but you do get a lot of misunderstandings of the importance of registrations at that level. And a lot of them think that state registration means something when usually it doesn't mean anything at all. A lot of them also think that being registered on the state corporate name register means something when that means nothing at all, because all the state corporate name register is looking for is that there's some difference so that we can identify whose tax documents are being filed. So I think you need to think about what the role of the register is. Is it meant to be a definition of what you can use in commerce, or is it just an initial cut, sort of a place to reserve a name and sort of a private fence in that way to warn people off? But then if people go beyond that and actually are using it in commerce, we need the courts to have a more detailed, muddy, if you will, analysis of the situation.
Right. Well, so here's my question. Do we need courts to have a more detailed analysis? So the argument for why it should be what you can use is predictability. Then you know, and it's true, people who are not legally sophisticated do lose out here, and they may be surprised to find that they can't use things. On the other hand, the register actually might settle something. If it doesn't settle something, then what is the registry for? When you say, you know, it's an initial cut, if the initial cut turns out to be meaningless when you go to an infringement inquiry, then, you know, we are spending a lot of money for something that doesn't seem to do a lot. I mean,
I wouldn't agree with that. Right? The fact that it doesn't mean much in the courts when you get to the cases that are litigated does not mean that it does not mean much. There are a lot of cases that never get to the courts because one of the parties sees it on the register for someone else and picks a different mark.
Right, and I think that's definitely true. Although we could stand to learn a lot more about that.
But that's very hard to measure.
It is very hard to measure. And then when you get into the actual litigations, like if you look at the sort of branding stories that even the big companies tell, they're like you know, the marketing department sees something in the register and they're like, but really, is it really the same thing? Are you sure? If they really want to use it, they tend to use it. So, but also, if there are a bunch of smaller entities that are being warned away, then maybe we should make it substantive so that it isn't available for abuse in precisely this way, right? So if only smart entities get to decide, okay, I'm going to investigate how much it's actually being used, then that's a problem too, it seems to me. I'm sorry, yeah.
A couple things. So I think these state registrations that aren't trademark related do play a role. When you get a CompuMark search, right, you see lots of things besides just trademark registrations, and cautious companies won't even file an application if there's substantial use. Even in blog searches, right, the common law portion of the CompuMark search that really is just Google results, right? A lot of times companies, especially incumbents, won't proceed, right, to apply for these things in the first place, which may account for part of Arden and Jeannie's findings, but certainly not all of it. My question for Rebecca is, you know, what implications does the forehand backhand choice have for the First Amendment, which you've written about before, commercial regulation of speech, especially in light of, you know, this recent license plate issuance case and subsequent developments to your previous knowledge?
Yeah, so I have tried to dodge that in this project. That is, I think you can come to an answer. So if we say registration is substantive, there are actually two possibilities. One is it's substantive and 2A is constitutional, right? Which is to say that granting rights only to non-disparaging marks under the common law or it is constitutional, or it's not. And I guess I think nothing turns on this. And even if registration is just procedural, then it's most of the TAM and pro-football arguments against 2A still remain in place. So
I guess I'm less interested in 2A and more about trademark as commercial speech
right.
broadly.
So I'm a regulation supporter. So I have no trouble with the government saying, okay, we're going to make a set of categorical rules because that is more likely to work out on average than these fact-intensive determinations. So I would say that even if it's substantive, I have no particular problem with the PTO being the decider on that.
Oh,
Yeah.
yeah, so I was curious about maybe the doctrine relating to disclaimers and how that interacts with registration. So it comes up for us where the question we have to face is, what do we do with words that are disclaimed? And it would appear that the court approach is almost to ignore the fact that language is disclaimed and compare the marks as wholes. And so how does that, what are the implications of that?
Right. So one thing that I would love to do by defending the substantive approach is to say this is a way we can actually push back against the primacy of confusion liability based on these terrible theories of confusion. If you took registration seriously in that sense, I think you would have really good grounds for saying, look, as a matter of law, liability cannot be based on similarity that comes from, you disclaimed these for a reason. The PTO allowed the mark with the disclaimer for a reason, and that is essentially a concession that other people get to use it. And that you would have to identify confusion stemming from similarity not related to the disclaimer portion.
Is the distinction between how the USPTO has been handling dilution arguments and oppositions and translations versus how courts handle that, especially the First Amendment issue, does that implicate any distinction you can draw between substantive and procedural?
So, like the dilution hater in me wants to say yes,
Right.
but here's the thing, like either the PTO is right or it's wrong, in my view. So I think the PTO is wrong in how it analyzes dilution, but once we've decided that we're going to make these determinations, and especially I think given Glenn's point that the register actually operates as this thing, especially for small clients, I think we should just face up to it. If dilution is constitutional, then the PTO can make determinations about it. If applications of dilution at least are unconstitutional, then they're unconstitutional sort of no matter who's doing it. So for example, the parity test that they use, right, where they've rejected the Four Circuit's Chewy Vuitton test, and it's essentially impossible to register a parity mark that's diluted. I think that's wrong, but I would rather face up to it. I mean, either let them on the register or not.
So I really don't know the answer to this question, but I wonder if there's anything to be learned by looking at registration systems in other countries, where generally one would find sort of a more substantive approach than it was understood in the U.S. system. And so I guess two thoughts. One is I wonder whether that would say anything about what a more substantive choice might look like, what the results might be, what kinds of effects that might have, and then two, I wonder a little bit about to what extent that then creates spillover effects in the choices that at least sort of major international companies are making with respect to the U.S. system and the way that they're thinking about the choices that they make in the U.S. system, and the extent to which then the choices that they make that then need to be informed by more substantive systems elsewhere then need to, they end up needing to make the same choices in the U.S. kind of regardless of whether or not we go a more procedural or more substantive route.
Let me take the second one first, because I think those are both fantastic questions. And my sort of eyeballing, at least the trademark registration discussion list, is that the other systems clearly do influence what at least major companies are doing. And they want to file in the U.S. so they have a basis to file in other countries if they're U.S. based. And that, to me, again, is actually another argument in favor of substantive. So if they're going to behave like the system is substantive regardless, then maybe we should make it so, at least to even the score. I think it is true that, so other countries have a more substantive approach. I think we could learn several things. So first of all, they tend to have formal double identity. So same mark, same goods, no further inquiry is necessary. And that's actually consistent with incontestability as initially understood, or at least as some people initially understood it. We've abandoned that. I think we could fruitfully return to that if it came along with the recognition that outside of double identity, substantially more is required to suppress a use. And I think that's the big change. The problem is, you know, with trademark, I think as Mark Lemley says, every time some trademark owner gets X, every trademark owner wants it. So, you know, everyone wants dilution protection. Everyone wants to be protected against, you know, uses in similar fields. And double identity might actually be a way to strike back against that, to say, no, you know, there's a set in which you are protected, and then your rights diminish. In fact, they fall off pretty sharply. It is interesting because we think of these other systems as more expansive. In many ways they are, although in many ways that's actually because of broader traditions around advertising and the First Amendment, not necessarily something internal to trademark. So you do see things like a more robust trademark use principle in these systems, and sort of absolute rights to, you know, make spare parts. And I think actually we could learn from the comparison.
1 minute. It's a great project, Rebecca. Let's assume you go with the substantive. So you're not willing to allow real use to expand. Would you be comfortable with real use being allowed to contract after a certain period of time? That's sort of point number one. Point number two, which gets back to the whole debate in around 43 and 44 in 1946, which is whatever position we want to adopt on the scope of the registration, you also have to play and be very conscious of what you do with 43A. Otherwise, you simply end up with someone parallel pleading for the expanded use-based rights upon a 43A action.
Yeah, so that is something I really need to think through, and I'm thinking actually about harm as the way to do that. I think I'm out of time, but thank you. That's very helpful.